Next, I will introduce for the Malaysian Anti-Sexual Harassment Act 2022. The Anti-Sexual Harassment Act 2022 is a landmark legislation in Malaysia aimed at addressing and combating sexual harassment in both the workplace and broader society. And this act was enacted in July 2022. The law reflects a major commitment to fostering safer environments by preventing harassment and protecting the right of victims. Uh, there are three key features of the Act include definition of sexual harassment, which covers a wide range of inappropriate behavior, ensuring comprehensive protection. And next is establishment of the Tribunal for Anti-Sexual Harassment. That's a dedicated body to handle cases with efficiency and accessibility. And lastly is preventive measure to encourage education and awareness program for organization and institution. This aid serves as a critical step toward promoting dignity, equality, and respect for all individuals, setting the stage for a safer, safe, and more inclusive nation.
Now let's move on to the next part, which is emphasize of the Act. First of all, let me introduce the brief history of the Act. As we all know that this Act has been enforced in 2022. Therefore, long before the 2022, most of the sexual harassment provision has been used by using the Employment Act 1995, which is Section 501 and 354. However, this provision is quite limited. It's not enough to cover most of the problem, most of the issue, most of the situation of the harassment. Therefore, some organizations such as WAO, which is Women Aid Organization, and AWAM, which is All Women Action Society, had decided to adopt a new act that focused mainly on the sexual harassment in the workspace. And after the making of the Act, after the alteration, after the amendment, finally the Act has been enforced in 2022, which is it had passed on Dewan Rakyat and also Dewan Negara, which is the Senate. Now let's move on to the structure of the Act, which is the main structure of the Act. Okay. The structure of the Act has four main parts consisting of a total of 27 sections. Now let's move on to the part one by one. I'm just going to explain just a brief explanation of each part. Alright, the first part is preliminary, which is it cover the Act's title, the definition, the scope of application. It also defines the sexual harassment and explain the Act applicability in various contexts, which is in this part, the Act cover mainly on the title of the Act, also the definition. What are the definition of sexual harassment? What are the type of sexual harassment, such as verbally and also non-verbally, which is a physical. Verbally, such as using a bad word, using a negative word, sexualized word that would give a bad and also negative impact to the other employee. While physical touch is physical without consent and also involved in sexual touch. Okay. It also applicability in various contexts, which is in what context that apply on the sexual harassment, in what situation that sexual harassment actually applies. Okay, now the second part is Tribunal for Anti-Sexual Harassment. Alright, long before the enforcement of this act, most of employees that are related, that are the suspect of the sexual harassment, they make a police report on the issue. However, in 2022, the minister had decided to make a body, which is a party, which is the tribunal, to take care all of the problem, to take care all of the complaint, the reporting. So therefore, person or employee that are related to the sexual act now doesn't need to make a police report. However, they can go to the tribunal to make a complaint. So the tribunal would take care of the report of the complaint, mainly focused on sexual harassment. Alright, now what are the section is actually talking about? Okay, the first one is appointment and member, which is the appointment of the tribunal's body, which is the members appointment. who are the person is going to be, which is the person that are going to be employed in the tribunal is going to be selected by the ministry, and also the person must have a wide experience and expertise in legal issues, and the tribunal also will have a list member of 5 members. And also the disqualification. What are the disqualification of the members of tribunal, which is some of it is undischarged bankrupt, which is the person had committed an offense. So therefore, after all of the disqualification, that person that are being the member of tribunal can no longer be a member of tribunal. Alright, the jurisdiction, proceeding and complaint form, which is how are the tribunal going to do after the complaint has been made. After the person made the complaint to the tribunal is going have their own procedure, have their own fees, have their own compliance, have their own ways on managing that report or complaint. Alright, let's move on to the third part, which is administrator for anti-sexual harassment. Alright, unlike tribunal, which is a party or body that will taking care of the complaint and also report of the sexual harassment, administration is actually higher than the tribunal, which is a minister that are going to make a policy or amend the act or another to ensure that the tribunal will follow all the policy made by the administrator. Alright, the main point of an administrator of anti-sexual in this act, they also had said that the member of the person of an administrator will be a same person as the Secretary General of Ministry responsible for women and family and community development. It should be the same person. Also the function and power of the administrator is it includes in amendment of the policy, making of policy, alteration of the policy. Now let's move on to the fourth section, which is the general. Okay, in this section, the act explained that in order to unlike the section 3, the part 3, which is administrator will make and alter and amend the policy. In part 4, it says that the administrator, in order to administrator to amend, to make or amend, to alter the policy, they have to make it that is suitable and also necessary for the tribunal, because tribunal is the party that will be the first person, the first party that will ensure that all of the report, ensure all of the complaint are to be reported, and also to be whether it is good enough, whether it is should be proceeding to the court or not. Alright, so therefore and also the act also provide that dual avenue are also applicable, which is like I mentioned before 2022, most of people that are suspect to the sexual harassment made a police report. But also even after 2022, they also can still make police report and also make a report to the tribunal. So therefore, the police report are also applicable to the sexual harassment issues. Okay.
So now let's move on to the importance of the Act. So firstly, to help victims to get justice, this is because based on the Section 3, this shows that there is a special tribunal is created to hear and resolve cases of sexual harassment. Number 2, raises awareness, because based on the Section 25 subsection 1 subsection A, this proves that the law actively promotes awareness to prevent harassment. Number 3, keep things private, because based on the Section 14, this guarantees the privacy of those involved in the hearings. Number 4, it covers all forms of harassment. Based on the Section 2, there is definition of sexual harassment. These have a broad definition to ensure the law covers all types of harassment. Next, number 5, encourage quick solutions. Based on the Section 16, subsection 1, this demonstrates the focus on resolving complaints efficiently through mutual agreement. Number 6, strong penalties for the offenders. Based on the Section 21, subsection 1, this to ensure offenders are held accountable. Number 7, support existing laws. So based on the Section 27, this allows the victims to seek help through both the tribunal and the criminal justice system. Number 8, to guide prevention efforts. Based on the Section 25 subsection 1 subsection B, This empowers the authorities to actively work on the preventing the harassment.
So my name is Wardina and I'll present about major provision for this Anti-Sexual Harassment Act. So there's four major provisions for this act. The first one is establishment of tribunal, which is from section 3 to section 4. This provision is a dedicated tribunal to handle sexual harassment complaints, and it also composed of legal expert and experienced individuals. Okay, so the next provision that is one of the major in this act is jurisdiction and proceeding, which is applicable from section 7 to section 19. So to summarize, to this provision, it handles complaints post implementation of the act, and it closed hearing to ensure privacy. It is also authority to mediate settlements or issues award such as compensation, which is up to 250,000 ringgit Malaysia, public apologies, or mandated program. So the third major provision from this act is administrator's role, which is applicable from section 24 to section 25. This provision oversees policies, awareness campaigns, and implementation of preventive measures. And the last provision is general provision, which is applicable from section 26 to section 27. It is about ministerial authority to regulate tribunal procedures, and it has complaints to do not prevent lodging a police report for criminal action. So that's all from me. Thank you.
So let's move to the next part, which is case study that happened in Malaysia, and the title of the case is Muhammad Rizwan bin Abdul Razak versus Asmah binti Haji Muhammad Noor 2016. There were two parties involved in this case, and the plaintiff is Muhammad Rizwan bin Abdul Razak, a general manager at the company, and the defendant Asmah binti Haji Muhammad Noor, a subordinate under Rizwan's supervision at the same company. For the commencement of the act, which is this case was a landmark decision in Malaysia that introduced the thought of sexual harassment into civil law, which is Act of Anti-Sexual Harassment Act 2022. Next part is case overview. In this part, I will explain the incident in a short story. The incident starts in 2009, which is Asma lodged her formal complaints against Rizwan to the company's CEO for alleging sexual harassment, and the company conduct an inquiry. While there wasn't enough evidence to initiate disciplinary action, and Rizwan received a strong administrative warning. After that, Rizwan, aggrieved by the complaint and warning, filed a lawsuit against Asmah in 2011. He sought a declaration that the allegations were false and claimed defamation. In response, Asmah counterclaimed, citing emotional and psychological harms caused by the harassment. So, there were two primary questions that related with this case, which is the first one is whether a civil remedy for sexual harassment existed under Malaysian law, and secondly, this was the significant as prior to this case. There was no established precedent for claiming civil damage for such misconduct. Okay, the next part is court decision. This case has involved three levels of court to get the decision. And the first one is High Court, which is the defamation claim by Rizwan was dismissed due to insufficient evidence. And Asma's counterclaim for sexual harassment was upheld. Uh, the court awarded her 120,000 in damage, linking her suffering to Rizwan actions. And the next part is Court of Appeal, which is the High Court's decision was affirmed. And the last part in Federal Court, which is Rizwan appeal again, but the Federal Court not only upheld the lower court's decision, but also formally recognized the thought of sexual harassment as part of Malaysian law. The court emphasized that act of harassment causing severe psychological effect could fall under the thought of intentionally causing nervous shock.
Now let's move on to the important point from the case which has been presented by Iwan Mustafa. Alright, The court found that as the employee was someone who was vulnerable and was diagnosed with depression after the said incident, the circumstances of this case warranted after it fell under the tort law instead. There was no law that allowed sexual harassment survivors to bring a case to court. However, the court decided to take a judicial cognizance of the issue and created a tort of sexual harassment. That's all from us. Thank you for listening.